Lucy Letby is currently seeking permission to appeal her conviction at the Court of Appeal. Now, it's been reported that her appeal is subject to reporting restrictions, therefore there is only a limited amount of information that can be reported. But why is this? Is this her case being silenced by the Court of Appeal? And this is an argument I often see in cases where reporting restrictions apply, such as the case of Tommy Robinson. Or is there a legitimate reason for these restrictions being in place? Well, in this video I'm going to answer that question, as well as a couple of other questions that I've seen cropping up on social media with regard to Lucy Letby's appeal. Welcome to my channel, Andy on Crime, where I talk about high profile criminal cases in England and Wales and other aspects of criminal law. Now, before I get started, I have previously done a video explaining why Lucy Letby's initial request for permission to appeal was rejected, and that video is about 8 minutes long. But if you want the too long didn't read version, then you can only appeal your conviction if you can show arguable grounds that your conviction was unsafe. Now, the first avenue of appeal is that a single justice will consider your appeal on the papers, and if they agree that you've got arguable grounds for showing that your conviction was unsafe, then they will grant you permission or leave to appeal. In this case, the single justice did not find that there were arguable grounds, so permission was refused. Lucy Letby had the right to appeal to the full court following that refusal, and that is where we currently are. If the full court gives her permission to appeal, then they will go on to consider whether or not her conviction was unsafe. So what do we know about the appeal before the court? Well, what we do know is that Lucy Letby is appealing on 4 grounds, each of which involves a submission that the trial judge, so the judge overseeing the original trial, refused wrongly applications made by her defence team during her 10-month trial. And we also know that the outcome of this appeal will be announced when it is decided, rather than being withheld to a later date. So why are there reporting restrictions in Lucy Letby's appeal? Well, the first thing to say is that we live in a system of open justice, and that means that in general, evidence that is given in open court can be freely reported in the press and other media. But occasionally there will be a requirement to have reporting restrictions in a case. A classic example of this is that the name of a complainant in a sexual offences case cannot be reported, or anything which might lead to their identification, and that order will apply for life. On other occasions, it might be necessary where there are linked trials involving multiple defendants that require 2 or 3 trials. There will be reporting restrictions on the first 2 trials so as not to prejudice a potential juror in a future trial. In simple terms, it stops a juror from hearing some of the evidence in a previous trial which might be reported in the press, which might make them biased or unable to objectively decide the case, causing the defendants in the last trial to be unable to have a fair trial, which is enshrined in the European Convention of Human Rights, Article 6, and the Human Rights Act. Now, in the case of Lucy Letby, the reason for the reporting restrictions are quite simple. She is facing a retrial in June on one of the charges from her previous trial, where jurors were unable to reach a verdict. Now, the reporting restrictions will prevent any evidence or legal applications that might be made from being reported, which could be seen or heard by a potential juror, meaning she is unable to have a fair trial. So once the retrial is concluded, the full judgment in this case for her appeal will be published, so that the reasons for granting or rejecting her appeal will be known. So there is nothing untoward or sinister about doing this. It is very much being done to ensure that a fair trial can be conducted and that Lucy Letby has a fair trial. Another question that I've seen crop up on social media is, why is she being allowed to appeal again and again? Well, this is quite straightforward to answer. This is her first appeal against her conviction. She had her initial request for permission to appeal denied, so she is entitled to ask the full court for permission to appeal. Sometimes the single justice who considers the initial appeal can issue what's called a loss of time direction, which means that any time served already will not count towards your sentence, so in effect reset. But as Lucy Letby is serving a whole life order, this would make no difference to her. If permission to appeal is rejected again, then this would effectively be the end of the line for her, subject to any new evidence or new circumstances arising in her case. But it's really important that people are able to appeal their convictions, because as we've seen time and time again, there can be miscarriages of justice. I'm not saying that there is in this case. I wasn't present for the trial and I haven't seen the grounds of appeal, but we have that check and balance on trials being conducted in England and Wales by people having the right to appeal against their conviction. And the final question, again, that I've seen quite a lot, is why doesn't the court just grant her permission to appeal, given that the stakes are so high for her as she is serving a whole life order? Now, I've seen this quite a bit, with some suggesting that the judges are refusing to give her permission because the appeal judges do not want to admit that a mistake has been made by the trial judge. If that was the case, then no case would ever be overturned or conviction overturned by the court. The Court of Appeal judges are actually quite content to correct mistakes and quash convictions where mistakes have been made by trial judges. Ched Evans, the footballer, is a classic example where he was convicted of rape, but then this was overturned on appeal and he was acquitted in a subsequent retrial. And it's really important to remember that you cannot simply appeal your conviction on the basis that you disagree with the decision of the jury. If there were errors in the conduct of the trial, such as evidence wrongly admitted or excluded by the judge, then that would give you grounds for appeal. But just because you think the jury have got it wrong, that is not an arguable ground of appeal. And in the case of Lucy Letby, the reasons for her initial appeal being rejected, which were not published because it was dealt with on the papers by the single justice. It would have been that the single justice did not deem her to have arguable grounds to show that her conviction was unsafe, and therefore permission to appeal was not granted. The judge cannot take into account the sentence or the seriousness of the case. The single question that they are concerned with is whether or not the conviction is unsafe. That's all for this video. If there are any questions arising about the appeals process or this case in general, drop a comment down below and I'll do my best to answer. If you did enjoy this video, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.